I think I'm just gonna do a little intro of what we have been trying to do at our brokerage. I, I've kind of always been interested in pre-construction. That's where I started my business. And once we started this whole teaching webinars, David and I came across a lot of agents that were very interested in pre-construction. And we believe that there's, a huge just living in Toronto, there's so much possibility in increasing your business, just even putting in a couple of deals a year with pre-construction. But there's a lot of, because of lack of knowledge and information, there's that fear of the unknown with a lot of agents. And that's where we have brought in David to kind of tell us a little bit of the nuances of this particular business, because it is very different from selling a resale, so that the fear leaves us and we are able to jump in to this huge big pool of business. Also the fact that we have been trying to make connections with some of the marketing companies that market for the bigger builders. Intuition was, I think, our first one that we tried to make connections with. And now it's Melbourne Group. And I know David is working hard into bringing other companies in that we can connect with. And but for that, there's a minimum amount of deals that you need to put in to be on a platinum status. And all of us who've worked in it know that it's very disabling if you don't have that status, because then you fall off and you get left with whatever's the leftovers. You don't get the cream of the crop. So for us to be able to do that, we have to go in as a brokerage, so that every deal that we do, and that's what really helps with not just working with the builder, but working with companies like this, like Baker or Melbourne Group, is that they have so many different projects under their belts from different builders, that once we establish that kind of relationship with them, across the board, we get a platinum status with them. So for that, we really need to push for everybody to put their deals through the brokerage. And we have made this program available for all of our agents, where they can put their deals through the brokerage. We provide with the graphics, we provide with the projects, we provide with everything that's required from the builder end. And the deal has to go through the brokerage's name. And for that, we have a split of 90-10. Is that right, David?
That is, yeah.
Yeah, 90-10, and it'll cover all costs of everything that you will need in terms of your graphics, your message to your clients, and remember that everybody is able to, if they're going in as investors, people are able to take out, if they are homeowners, equity from their present residence and put in a 10 or 15% or 20% deposit, whatever is required. And then they are, benefiting from this investment as well. So I think we will let David go ahead with teaching us a little bit about the business of pre-construction and how to put an agreement of purchase and sale together that will work for our clients.
Okay, thanks, Sabiha, and thank you for having me today. And David, thank you as well for doing this. It's always a pleasure for me to deal with your group and see familiar faces. Nice to see people and just to see the names of those of you that aren't on with video right now. Believe me, I'd much rather be doing this at your office live, and I hope we all get back to doing that at some point. But this is a great way to communicate and provide some information. So I've got a fair bit to go through. I'm going to share my screen with you. Sabiha, if you can just confirm that you see it.
I do, yes.
I know we're on. Okay. And there's a fair bit of material here. And I think for those of you that haven't really dealt with new construction, you might find it a little surprising, how different it is from a resale residential type of transaction. There's just so many more issues. So I'm going to cover this from the basis of things that we look at from lawyers, but it's really the same type of issues that you as agents have to be looking for when you're involved in these agreements of purchase and sale. So there's a picture. I used to look like that. I think you guys are all pretty familiar with our areas of practice. And by the way, we're going to make this presentation available for all of you. I'll get it to Sabiha in a PDF form so she can circulate that so you'll all get that. You know, our offices are in Mississauga, Toronto, and Markham, so we're going to skip over that. And you know how to connect with us through social media. So let's get right to the nuts and bolts of this. So there's two different types of new construction. And first of all, there's two different terms that are used in describing this. Sometimes it's new construction, sometimes it's pre-construction. It really means the same thing. You know, pre-construction is typically projects that are marketed way before a shovel hits the ground. Sometimes people are just buying something that happens to be new and it might already be up. So the term is new construction, but it's the same concept, the same issues that come up. So when we're dealing with something, it's new condo versus new house is one thing that you have to consider. A condo, as most of you should know, has two stages for a new condo closing. There's an occupancy closing, and then there's a final closing. A new house only has one closing, and that's when the property is transferred to the buyer. When there's a condo, an occupancy closing is when the buyer will get possession of the property. They can actually physically move in, but they can't take ownership of the property until the final closing. From an agent's point of view, it's really important you get the names correct on an agreement of purchase and sale right from the beginning. It's really hard to go back to a builder and ask for amendment for name changes. So it should go without saying, but I'm going to say it anyways, that it's important that we read these agreements. It's important from a lawyer's point of view. It's certainly important from an agent's point of view. A buyer is not going to be familiar with it. An agreement of purchase and sale could be 20, 30, 40 pages long with a lot of fine print, all kinds of schedules attached to it. It's very difficult for anybody to read it line by line and understand the significance of what those are going to mean. So the important thing is point number 2 here, and you bring it to a qualified lawyer to review. And I encourage you to do that every single time. It's very important for us to get involved in the process as early as possible to see that everything is in place and to help guide you as an agent through it. And obviously, when I say bring it to a qualified lawyer, I mean bring it to Korman's LLP, because as you know, we're the only qualified lawyers in the province to deal with this. And I'm only kidding. There's many qualified lawyers. It's up to you as the agent to make sure you get someone that does do these types of reviews routinely and knows what to look for and has relationships with the lawyers that act for the builders in order to get things changed and dealt with. Okay, we do a lot of this in our office. We know the lawyers that typically are out there acting for the builders in these projects, and they're responsive to our communications to it. So when you're dealing with a new condominium, you should know there's a 10-day statutory cooling off period. So that means from the time the agreement has been signed and provided to the buyer with disclosure documents, the buyer has 10 days to get it reviewed by a lawyer and 10 days to basically back out of the deal if they want. If they find something that they don't like about it, they can get out. It doesn't have to be built into the agreement of purchase and sale. It's a statutory 10-day cooling off period. Now,
sorry,
that
David, can I cut you in for a second?
Sure.
I've lost David can you give me access as a host, because there are some more people wanting to join in?
Okay.
Sorry about that.
All right, no problem. Make you a co-host. You got it?
Yep, thank you.
Okay. So when it's a new house, there is no statutory 10-day cooling off period. Okay, so it's important that you as an agent make sure that the buyers have a condition put into the agreement of purchase and sale that it's conditional upon lawyer review. If it's not, it just becomes a firm deal as soon as they sign the agreement of purchase and sale, unless there's any other conditions, like condition for financing or something like that. But otherwise, we have no opportunity to review the agreement and to negotiate any potential changes to it. So that's an important point. Now, what do we look for when we're reviewing it? We're going to spend some time looking at that. The first thing that you should be aware of and we look out for is HST. New construction is subject to HST. The basic rule of thumb is HST applies to everything under the Excise Tax Act unless there's an exemption for it. So as it happens, there's an exemption for HST on resale properties. So there's many agents out there that just, because they deal mostly in the resale market, they just assume that HST doesn't apply to real estate transactions. So it's true for resale transactions, but that's not true for new constructions transactions. HST is applicable. Now, the good news is that most of the time, the way the builders structure these agreements is they have HST included in the purchase price. So if your purchase price is $500,000, that includes HST. And there should be language to that effect in the agreement, but we have to review it, make sure that that's there, because it usually is. On 90% of new constructions, agreement purchase and sale, that's the way the builders will do it. Now, we will talk in a few minutes about the GST HST new housing rebate, and that's a separate issue. The HST rebate issue is a separate issue from HST being applicable to the purchase price. Now, another important issue to look at is deposits. Are they insured? There's a difference in deposit coverage, whether it's a freehold property or it's a condominium property. For a freehold property, the coverage depends on when the agreement of purchase and sale was signed. It was signed before January 1, 2018. It's protected by Tarion, so it's a statutory coverage for this, up to $40,000 in deposits. If it was signed after January 1, 2018, that you have from Tarion is increased, and it's based on the purchase price. So if it's $600,000 or less, you have $60,000 of coverage. If it's over $600,000 in purchase price, you get coverage of 10% of the purchase price to a maximum of $100,000. So it's important to determine when the agreement was signed. And there still are agreements out there that were signed prior to January 1, 2018, specifically in the condo market. Sometimes it takes 3 years, 5 years for these, from the time an agreement is signed until the project is actually built. So we have to check those dates. Now, if it's a condominium, the coverage is different. So the Tarion coverage is a maximum of $20,000 of deposits. However, deposits above $20,000 are protected by the trust provisions of the Condominium Act. Now, what we do have to make sure is that those trust provisions of the Condominium Act are complied with, which is, again, where having a lawyer involved in this helps. But basically, it's the builder's lawyer that gets involved and has the deposits payable to the builder's lawyer in trust, and they deposit it in accordance with the provisions of the Condominium Act and will provide certificates to confirm that the money is being held that way. If there is not compliance with that, and if buyers make their deposit checks payable to the seller, the builder, and the builder goes under at some point, their deposits are in jeopardy. They're going to be standing in line with other creditors, and they're not going to have protection for it. So that's a crucial point to check what the deposit provisions say. Now, I mentioned before on condominiums, there's a two-stage closing. There's an occupancy closing and a final closing. So when there's an occupancy closing, it's called an occupancy closing, an interim closing, same type of terms. And this is for new build. At that point in time, the buyers will get possession of the property, but they don't get title. So because title can't be transferred to them, they can't get their mortgage financing. So this is basically a way for them to be able to move into the property, take possession, and instead of paying their mortgage lender mortgage interest, they pay an occupancy fee to the builder. Now, the occupancy fee consists of three elements. It's the estimated property taxes, it's interest on the amount that they're not able to pay the builder or not required by contract to pay the builder at the time of occupancy. So the builder charges them interest on that. And the third element is the estimated common expenses. So the total of those three items is what the occupancy fee will be. And we'll pay that monthly fee until we get to the final closing stage. And that's when title will be transferred. There's no more occupancy fees. the builder gets paid the balance of the money, and going forward, the owner pays property taxes themselves, and they'll pay common expenses themselves. Now, the interest that a builder can charge on these as part of the occupancy fee is determined not by the contract or by the builder unilaterally. The government decides what the rate will be and publishes a rate, and the builders have to comply with that rate. So it's dependent on what current interest rates are. It's not an exaggerated rate or an abhorrent rate. It's based on current market conditions, and the government publishes that rate. So that's what happens to the interim occupancy. They move in, they pay their occupancy fee. Now, usually they're paying an additional deposit at the time of occupancy as well. There's some documents that have to be signed where they agree to occupy the property and pay their occupancy fees. There's sometimes some adjustments that have to be paid at the time of occupancy, and I'll go through what builders' adjustments typically are in a few minutes. And at that time, we're usually determining how they're going to take title when we do get to the final closing and determine how the registered transfer is going to go to them. So we want to determine that at the time of occupancy if it hasn't been determined before that. See, is it going to be husband and wife going on title, just one of them going on title? Is somebody else needed to be added to title for mortgage financing purposes? We want to ascertain that. Now, when we get to the final closing, that's when title gets transferred to the buyer. That's when they're able to get their mortgage financing. And that's when the balance of their down payment will be paid. And going forward, they'll make their common expense payments. At that time, we have a meeting with the client, and there's a lot of documents that have to be signed, because we have documents that are required by the builder. There's purchase closing documents. There's all the mortgage documents that have to be signed. So it's a lot more comprehensive to go through that final closing process. Now, one of the real critical issues that agents should be aware of and look into is in condominiums is what's the story with lockers and parking spaces. How many lockers are they supposed to get? What size of the lockers? Where are they supposed to be located? And the same thing with the parking spaces. Is it one spot, two spots? Are they tandem parking spaces? What level are they going to be on? These are often very critical issues for clients. We've had clients over the years, especially elderly clients, that it's one of the main things in them choosing a condo is, where's my parking spot going to be? How close to the elevator is it going to be? Where's my locker going to be? Can I access it easily? Is it going to be easy for me to get things out of my locker to an elevator to get it up to my unit? So everybody has those type of concerns. What we do find a lot of times in condominium projects, there's a difference in description. So it's often takes a little bit of investigative work to figure out exactly where these locker locations and parking spaces are. There will eventually be a legal description for these spaces. It'll be described as a parking unit or a locker unit on a particular level of the condominium. Often that differs from the way the condominium management office will describe these spaces. Sometimes they just go into the parking garage and they just put numbers on the parking units, and those numbers don't correspond at all to the legal description. Sometimes the municipality is putting a different numbering system on these. So we get sometimes 3 different numbering systems to describe the same lockers and parking spots. We want to make sure we physically know where these are and that we're identifying them properly. Now, extension rights, termination rights, and delayed closing compensation are critical issues on new construction. And these rights, the rights of a buyer, the rights of the builder, are all determined by Tarion. So it's regulated by the province of Ontario. And every new construction agreement of purchase and sale in the province of Ontario is required to have a schedule attached to it. It's supposed to have 2 schedules, Tarion Schedule A, Tarion Schedule B. And it's compulsory that these schedules are attached to every agreement of purchase and sale. So you have to make sure that they're on there. Now, Schedule A covers things like the critical dates for closing, saying what the anticipated closing dates are and any anticipated potential extensions of those closing dates. So oftentimes there's something described as a tentative occupancy date, and that'll be firmed up at some point to be a firm occupancy date, and there might be a tentative final closing date, and eventually there'll be a firm final closing date, and then there'll also be an outside closing date described in these schedules to determine the timing for this project. So that has to be set out clearly in Schedule A. Schedule A also outlines the extension rights that the parties have. And by pursuant to the provisions of Tarion, the builder has certain unilateral rights to extend closing periods. And this has got nothing to do with COVID. COVID gives them some additional rights because it even takes it beyond. But they have certain rights to extend closings unilaterally as long as they give proper notice to the buyers. And the buyers can't do anything about that during that time period. But at some point in time, the rights of the buyer change because the builder gets beyond those time periods, and then buyer has additional rights, including the right to get out of the transaction if the delay goes beyond a certain time period or if they didn't get proper notice. Okay, we got to be very careful with these things because sometimes when a project is delayed, the builder sends a letter to the buyer saying, hey, we're delayed. We want to change your closing date from July 23rd till November 23rd. Here's an amendment, sign here. Now, if they sign that, then that changes all the dates in these critical dates. And that triggers the builder to have a right for unilateral extensions now that can start in November, when the builder may have already used up their unilateral rights. So it's important that we advise clients, buyers, not to sign any of those type of amendments without running it past their lawyer, okay? Because we have to look at how many extensions there have been, the time frame for extensions, and whether or not we want to sign an amendment or just allow the builder to use up their unilateral rights to extend so that any further extensions will give more protection to the buyer. So whenever you're acting with a buyer and they're presented with those type of amending agreements, don't let them sign it until we get a chance to review it. Okay, so as I mentioned, the buyer gets termination rights that get triggered at some point. And if that's a couple scenarios, one is if the home has not been completed by whatever the outside date is, that was part of the critical dates, then there's a window where the buyer can terminate as long as they exercise their rights properly within that window of terminating. And the other situation is if proper notice was not given by the builder. And again, the buyer may have a window of 30 days to terminate. And if they don't terminate within those windows, then they're deemed to continue in the transaction, and it moves towards whatever date the builder has set, and the buyer is obligated to close. Now, there's also compensation rights that's also set out in Schedule A, the Tarion Schedule A, and the buyer may be entitled to certain compensation because of the delays. So the total compensation amount is limited right now to $7,500, and it includes $150 per diem for certain living expenses and accommodations and meals. And some of these other costs are for things like storage and things like that. Whether or not they're entitled to it, we have to go through and look at it on a case-by-case basis to see when the notices were given. Were they given in proper time frame? Is the builder out of their rights for these notices? And then some of these expenses have to actually be supported by invoices showing costs and expenses that have been incurred by the buyers for storage, for moving cars, for having to check into a hotel if need be, things like that. And then you have to be mindful of the limits and the maximum of $7,500. Sometimes we get in those situations, we can negotiate directly with the builder for an amount to be payable as compensation in exchange for waiving the rights to make a claim for compensation after closing, just so you're aware of that. Now, I mentioned earlier there's a bunch of adjustments in agreement of purchase and sale, so I want to just highlight some of what these adjustments could include. So basically what this is you may be buying a condo for $500,000, and that's your purchase price. But the agreement of purchase and sale from the builder will typically say that in addition to that purchase price, the buyer is going to be responsible for certain other costs, and these are typically referred to as adjustments. There's usually an adjustment clause that outlines them in the same place, but sometimes these adjustments and costs that are passed on to a buyer are hidden elsewhere in an agreement of purchase and sale. So that's another reason why it's important for you as agents to be looking through the agreement and reading through it and getting a qualified lawyer to look through it so we know what to look for. So some of these costs are relatively minor, some of them are really significant. The first one on this list here, any new taxes or increase to existing taxes. This one potentially could be a large amount. At one point in time, there was no such thing as HST in the province of Ontario. And then the government came in and said, okay, we're going to have GST, and then we're going to have HST. So anybody in those days that had buying from a builder that had a clause that said any new taxes imposed by a government are the responsibility of the buyer. So all of a sudden the buyer and not the builder is responsible for new taxes. And we never know when a new tax is going to come into play. And we're in a situation where agreements are being signed 2, 3, 5 years before they're physically constructed. So we never know how many governmental changes there might be on a municipal level, a provincial level, federal level that might impose a new tax. So basically the builder is saying if there's a new tax imposed, the buyer is going to take the risk and be responsible for that. Tarion enrollment fee is just a cost. Every new construction has to be enrolled with Tarion. Tarion charges a fee for that type of insurance coverage. Builders will always pass that cost on to buyers. It's not something that we generally are able to negotiate out of the contract, but we have to let them know that it might cost them $800, it might cost them $1,000 for the Tarion enrollment fee. Upgrades and extras are a little more obvious. If the buyer is going to be ordering some upgrades or some extras or do change orders, they're obviously going to be paying for those things. Utility meters, installation, connection charges are costs that are typically passed on, and this could range anywhere from $750 to $1,500 typically. And all it is just a cost being passed on by a builder saying, we want you to pay for installing your meters for hydro, gas, and water and connecting them to the services. So we're going to pass on this cost to you. Ontario levy, for lost society levy, right now that's about $70. It's not that significant. It's just a cost that gets passed on. A check tendering fee, builders typically say for every check that you give us, we're going to charge you an administration fee. It might be $50, it might be $100 per check. Sometimes it's more. Oftentimes in new construction, there's a process of providing 5, 6, 7 deposit checks. So if it's $100 a check that they're charging, then there might be a $100 fee at the time, $700 fee at the time of closing for that. On a condominium, there's administration cost for complying with the Condominium Act, for administering those deposits through the builder's lawyer. Usually they'll charge an administration fee for that. There's a reserve fund contribution, whoops, I skipped over it, that has to be paid. It's usually equivalent to 2 or 3 months of common expenses. That's something that has to be paid at the time of closing. There'll be common expenses for the month of closing that has to be paid. There'll be an adjustment for occupancy fees, partial discharge of mortgages. This is one that I always find offensive and try to get out, but it's not always successful. All this is a builder gets financing, construction financing to build their condo or to build a house. Sometimes they get one mortgage. Sometimes it might be registered 2, 3, 4, or 5 mortgages for their construction financing. When we close the transaction, we have to discharge those mortgages against the particular unit that our clients are buying. There's usually a provision in there that they will charge a discharge fee. Sometimes it's $150, $250, $350 for each partial discharge. So if there's 5 mortgages registered that have nothing to do with the buyer, that's the builder's own business, but he might have 5 mortgages and each one has to be discharged. So they can charge 5 times $350 to get rid of those mortgages from title. It's just a cost passed on to a buyer and it's got nothing to do with the buyer. So we try and get that eliminated if we can. If it's a condo, there's a status certificate that has to be provided. Sometimes There's a $100 fee that's passed on to a builder for providing the status certificate. The next one, an item 13 here, is a real important one. This is new or increased to development charges, transit levies, park levies, education levies, things like that. When a builder prices out a project, they have to pay certain costs to different governmental authorities. On the municipal level, they're paying for development charges. Sometimes provincial level, they're paying development charges, transit levies. They have to contribute to parks being built, to schools being built, to roads being improved, to sewers being improved, things like that. So these are all costs that the builder is going to be paying for as part of the development charges. So if the builder prices out to determine what their price for a condo is going to be, they take these into consideration based on the known charges at that time. But they want the buyer to take the risk if there's any new charges imposed, if there's a change of government, or if there's any increases in any of these charges. They want the risk to be to the buyer. And oftentimes, because we have this 2, 3, 5 year time period go by, and there's changes in governments, there oftentimes are these additional levies or increases to existing levies. This sometimes could be zero. Sometimes we've seen it being, $15,000, $20,000 in increases. So it's important for us to try and determine whether or not, where this project is, what might be included. And sometimes we can't eliminate a clause like this, but a lot of times we can negotiate to put a cap on it. So at least maybe they put a cap on it at $5,000. So at least the buyer knows it might be subject to these increases. It might be zero, but it won't be more than $5,000, and they can budget accordingly. That's way better than for it to be open-ended, and comes time to closing, and all of a sudden they're hit with a $15,000 or $20,000 charge, and they're scrambling to get their money together to cover it. Just to quickly go through some of these other points, utility security deposits are sometimes have to be paid. Sometimes there's charges for doing wire transfers or direct deposits. Sometimes the cost of a survey is passed on to a builder. We've seen costs of carbon monoxide detectors being passed on, and occupancy fees. I think we've got that in there twice, so that should only be in there once. Anyways, bottom line is you can see there's all these adjustments. Sometimes it's clear where they are in agreements, sometimes they're hidden. The good news is that the government decided a few years back to require a Terrian Schedule B to be attached to every agreement of purchase and sale. And the purpose of Terrian Schedule B is to summarize all of these adjustments, to pull them out of the agreement, put them all in a summary in one place so you can see them. So they have to refer to the section number in the agreement of where these adjustments are. And if the adjustments have a specific amount attached to them, then that amount has to be shown in Schedule B as well. So if they put in that they're charging $300 for every partial discharge, and states that in the agreement, then it'll state that in Schedule B. So you have a nice summary there to take a look at it. If it doesn't say the amount, it'll still be in Schedule B in a different column, and it'll just say, section 4.3 or something of the agreement is partial discharges, and there's no amount there. So then we know we've got to write a letter to the lawyer to see if we can either get an amount put in there so we know what the cost will be, or we always try and get these costs waived. But it's important for you to look at that schedule, because that's where the summary is of all these costs. And you've got to point that out to the buyer as well, because what we all want from both your and my end, we want an informed buyer. We want them to make an informed decision, and they have to know their purchase price might be $500,000, but there might be $15,000 or $20,000 or $25,000 of adjustments payable on closing as well. And then the exercise we go through when we review this is, can we get rid of some of these? Can you as an agent get some of these negotiated out? Can we as lawyers, when we get involved, can we get these negotiated out completely to save our clients some money? If we can't get them deleted, can we at least get them capped? Can we put a number to it so we have some more certainty of what will happen on closing? Okay. Now, a lot of times, your success as an agent in doing that, our success as a lawyer in doing that really depends on the market conditions at the time. We just had a lawyers meeting in my office this morning, and we were talking about this. And we have some projects where pre-COVID, we would write a letter, ask them to, delete or cap all these adjustments, and we're getting an answer back saying, no, we're not doing anything. We're not touching anything. Your client doesn't want it. We got someone else to take the unit. They weren't doing anything. In some of those same projects right now, because they were all shut down for a period of time with COVID, and now they're reopening and getting back to market. So some of them are now being receptive to our requests to adjust on some of these things, or cap them, or delete them. So yeah, at some point in time, we might get an answer that's no. Market conditions change a little bit, and we might get more results. And I think you'll find the same thing. But bottom line is, we want to get an informed client. We want them to decide whether to go forward on this based on what the real costs are going to be.
David, can I butt in for just a very
Sure.
quick second, just because
Sure.
I don't want this moment to pass. So guys, this is actually one of the negotiating factors, is a capped levies and taxes. And most of the builders will advertise that. So when you're taking your clients to a pre-construction site, do not be shy to ask what cooperating commission they're going to pay you, and if they're cooperating with agents, and also what the cap is, because the assignment, which I'm sure David will cover too, is that if there's an assignment clause and if there's a cap to the levies and taxes, because just up front, there's a lot of builders that will actually advertise the capped rate. So $12,000 or $13,000 will be the levies and taxes. I'll give that back to you, David.
Yeah, that's a great point. And the caps that they sometimes put in cover certain things. And you have to be careful in looking the language they use for what exactly is being capped. So there might be that same list of 15 adjustments, but their cap might apply to 5 of them. And it might be the 5 most important ones, or the ones that we worry about the most. It might be to 3 of them, it might be to all those adjustments, but usually it'll set out exactly what they are capping and what they're not capping. So it's important to take a look at that as well. Okay. Now, we'll shift gears a little bit. I mentioned this before. Another point that we want to look for is, what does the agreement of purchase and sale say about the GST HST new housing rebate? Now, typically these clauses are fairly consistent from a builder's point of view. And what it basically says, but it's going to be a page or 2 pages of fine print to go through it. But I'll tell you basically what it says. Every agreement purchase, we'll use that same example. Let's say you're buying, your purchase price is $500,000. Now there's a rebate that's available through the government, an HST new housing rebate. So what an agreement will typically say is, if the buyer, what we just say that the buyer represents and warrants that they will qualify for that rebate, and they will sign that rebate to the builder on closing. So let's just say that rebate is $24,000, which oftentimes it is. So what the builder is saying is, I'll sell you this unit for $500,000. You'll apply for the HST new housing rebate and assign that to me. So I will get $24,000 from the government. So at the end of the day, the builder will get $524,000. Because it's the buyer that has to apply for that rebate. Okay. Now, what the agreement will go on to say is, if the buyer does not qualify for that rebate, the buyer agrees to pay me, the builder, an amount equal to that rebate in addition to the purchase price. So if the buyer doesn't qualify to get the rebate from the government, the buyer is going to pay $524,000 to the builder. So either way, the builder gets the full $524,000. Now, the question you're probably asking yourself, okay, what's the criteria for being eligible? Okay, so in a nutshell, the eligibility depends basically on, first of all, it has to be new construction, etc. But the buyer has to be buying it for their own purposes. They have to be moving into this property. They have to physically move in and intend to move in at the time they sign the agreement, and then move in on closing for them to be eligible for that. So if this is an investment property, they wouldn't qualify for that new housing rebate. So if it's an investment property and the buyer's never going to move in, you have to inform the buyer that on closing, they're going to pay their $500,000 purchase price, but they're also going to be paying $24,000 to the builder, because the builder is not going to be able to get the money from the government. So the buyer
What
has
about
to
the rent rebate though?
we're going to get to that in a second.
Okay, sorry.
So it's the buyer moving in themselves, or it can be an immediate family member, relative, blood relative. And at the time of closing, the buyers have to sign sworn documents that, yes, it's my daughter moving in, my daughter's name is so-and-so, and you're swearing under oath for the builder and for the government of Ontario, actually who is moving in as their primary place of residence in order to qualify. Okay? Now, Sabiha's point that she was raising is, let's say it is an investment property. The buyer has to pay that $524,000 on closing. Now, if the buyer then leases the property out, because that's their intention, they're going to rent it to somebody, there's a different program, which is the GST-HST rental rebate program, different from the housing rebate. So this is the rental rebate, where they can apply to get that money back from the government. Okay, so they basically paid that $24,000 to the builder, but now they can apply under the rental rebate program to get that money back from the government. Now there's certain criteria they have to comply with. There's an application process. They have to show that they actually paid that money to the builder. So we send a copy of the agreement of purchase and sale to the government. They'll get a copy of the statement of adjustments. And they'll also get a copy of the lease, because you have to lease out the property. The government wants to see the lease. Now the lease has to be a bona fide lease. It has to be to a third party, and it has to be for at least a 1-year term. Now people have been trying to scheme around this. The government is onto all these schemes. And even if they pay it out, they're provided with a 1-year lease and the government pays the rebate out, they have audit rights that can last 6-7 years or longer. And at some point, if they go back and they say, yeah, we paid out that rebate, but it turns out we found out that lease didn't last a year, and it was just a scam to get the rebate. And as soon as they got the rebate, the people never lived there, they never moved out. They have the right to go back and audit and recover these monies with interest and penalties. So you got to be very careful in the advice that you're giving people, because people are always trying to scheme around their eligibility for the HST new housing rebate and their HST rental rebate. So it's important, and I always tell clients, you won't look good in an orange jumpsuit because it basically is fraud when you're trying to get around this. So there's lots of ability to comply with one or the other, but we got to do it properly. Okay, now we're going to talk a little bit about rights to assign and lease and market and things like that. Almost every agreement of purchase and sale with the builder starts off with a clause in it that has an absolute prohibition against assigning their agreement of purchase and sale or leasing it out or market it and things like that. And why is that? It's basically because the builder doesn't want competition with their own sales. So that's generally their starting point. They don't want to sell this to people who are just going on the market just purely to flip it. They want to have some control over the process. So generally there's a clause that really provides an absolute prohibition. It usually has language that says you can't directly do it, you can't indirectly do it, you can't sell an interest in it. It's usually comprehensive language. You can't do any of that unless you get the builder's consent. If the builder consents to it, then you can do certain things. And usually it says the builder's consent can be unreasonably withheld. So if someone signs an agreement that says that, they're at the mercy of the builder. They can't assign it, they can't lease it out, they can't market it without going to the builder, and the builder can just point to that clause and says, no, I'm not consenting, and I don't even have to be reasonable about it. Okay? So, and if you violate that clause, the buyer is in breach of the agreement of purchase and sale, and it gives the builder the right to terminate. So, and we've had many situations where people have violated those clauses, and we get a letter from the lawyer acting for the builder, basically saying, you know, pointing out that this was advertised on MLS or was advertised on Facebook or something, and that's in contravention of this section. The buyer is in breach of the agreement of purchase and sale, and we have the right to terminate the transaction. And sometimes they say they are, sometimes they say we have the right to, but they might go on to say they won't terminate as long as you agree to cease and desist from doing any of that and pull all your advertising away, etc. But they're within their rights to terminate the transaction and to keep the deposits. And there could be $100,000, $200,000 of deposits there. So it's really important that you understand what the language in these clauses say. And if you do get the opportunity before an agreement is signed, then that's the time when you want to go to the builder and see if you can get some language to soften up some of these rights. And sometimes we can get the builder to do an amendment to it to say, okay, you still need our consent, but we're going to outline the terms and conditions right in the agreement of how we're going to consent and what type of conditions might be included in that. So oftentimes, most of the time, one of the terms for a consent would be that the buyer pays an administration fee to the builder. Now, we've seen these administration fees go from very minimal amounts to you know, of hundreds of dollars to thousands of dollars and even $50,000 plus HST. We had a situation, I think it was back maybe last September, on one project. We had two clients, both asked for consent. One got consent approved by paying a $3,000 administration fee. 2 weeks later, we had another client, we asked for consent, and they said, we will consent, but we're going to charge $50,000. We pointed back to, you just did one for a client for $3,000. We argued back and forth with the builder. The builder didn't budge on it and insisted on $50,000 just because market conditions had changed. They're getting too many requests for these. They didn't want to do them anymore. They said, we're only going to do it if it's make it worth our while. They insisted on $50,000, and our client agreed to pay it because they wanted to assign the agreement to someone else. Most of the times, the buyer is going to have to pay the builder's legal fees for dealing with the assignment, and it could be there could be a range in that as well. Sometimes we try and pin them down on what those fees might be, but it's usually anywhere from $500 usually to a couple $1,000s for dealing with an assignment. A lot of times, even if the builder does consent, one of the conditions will be we consent to you having the right to assign, but you can't advertise it on MLS, on WeChat, on LinkedIn, Facebook, any other social media. So they say, yeah, we're going to consent, but we're going to tie your hands up as an agent completely for how you're going to market this. So if you can find somebody within your office, advertise within your own office and see if you can find somebody that might be interested in it, you know, by all means, we'll consent to that, but you cannot advertise it on social media. You cannot do a listing for it. So it's important to take a look and see if there's prohibition against that. On certain projects, the builders take it a step further and they just have their own real estate firm. Sometimes they've got a piece of the action on it, and they say we're only going to consent to an assignment or an ability to lease out these units if you use our real estate firm. And you know, and because we're only going to pay commissions through that, and that might cut you out as an agent. So you got to take a look at that when you're deciding which projects to take your clients to. You might want to stay away from projects like that because they're not going to be agreeing to provide you with a commission on any assignment or a subsidy or leasing out. And this is all ability to lease out or assign it prior to closing. Once you have your final closing, the parties can do with the property as they want and retain you as their agent. So a little bit more on assignments. And assignments are extremely difficult because they're complex. They're difficult for lawyers, they're difficult for agents to go through, they're certainly difficult for buyers. We've done seminars at your office before on assignments. I think we might be trying to schedule that again. It's always good to revisit it. There's so many issues that come up now on assignments. When I've recently done assignment seminars, we've had to split it up. Excuse me. We've had to split it up into 2 assignments seminars because there's just too much material. There's so many tax issues that come up on assignments and considerations. So I'll just give you a little overview of some of the things that come up on this. And I can tell you on any assignment, it's really important that there be a legal review. It's critical. It's also important to get an accountant to review it and get some tax advice because there's so many tax issues that do come up on it. One is the HST tax that we talked about up front. There's HST payable on the transaction itself, but there's also HST that's applicable on assignments. And who's going to be liable to pay HST that's applicable? Is it the assignee or is it the assignor that's going to be paying for it? These are things that have to be negotiated. Who's going to be paying fees to the builder for consenting to the assignment and the builder's legal costs? Whenever there's an assignment of pre-construction, once the builder does agree to it or consent to it, there's a 3-party agreement that is entered into between the builder, the original buyer, and the assignee, who's going to be the new buyer. And they all have the respective lawyers that have to deal with this, but the 3 parties have to deal with this. And this is a document that gives the builder's consent and imposes certain conditions. So it's a negotiated agreement. Builder's going to charge fees for that. Their lawyer's going to charge fees for that. It's going to be paid by the assignor or the assignee. That's part of the negotiations. Okay, so we have to look to see what the original agreement of purchase and sale says. What does that clause say? Does it specify who's going to be paying it? If not, it's generally the assignor that will be paying those costs, but we have to look at it, see what's in there. We've got to make it clear. Is it the assignee paying all the costs and the adjustments with the builder on closing? That's typically the case. We want to make sure that that's the story, that it's the assignee who's eventually going to close this with the builder, is going to pay for that whole shopping list of adjustments with the builder, and not the original buyer who just wants to get their deposit money back and they want to get their profit. If it's gone up in value, they just want to get out of it and move on. Okay, we have to look at the closing dates when we're doing assignments. Do the closing dates of the assignment match up with the closing dates of the agreement of purchase and sale? There's conflicting timing issues about when an assignment is going to close. Is the assignment transaction going to close right away? You know, an assignor wants it to close right away because they want to get paid right away. They want to get their deposit monies that they paid to the builder. They want to get that back. They want to get their profit back. Oftentimes, the assignee can't close an assignment until there's a final closing of the transaction with the builder because they need their mortgage funds in order to pay the assignor the money that they have to pay them under the assignment transaction. So that creates issues and timing issues. When you're doing an assignment transaction, there's a standard form assignment agreement of purchase and sale that you'll be using. There's a Schedule B to that a lot of people find very confusing because it has to set out all the different elements that go into it. So there's an assignment price, which is the price that's going to be paid by the assignee to the assignor. So if it was a $500,000, well, in this example, it was a $400,000 original purchase price between the builder and the assignor. Our new price is $500,000. So the intent here, this is being flipped for a $100,000 profit. Okay, now part of the assignment transaction, there'll be a deposit paid from the assignee to the assignor. So there's that deposit. In this example, that was a $20,000 deposit. So there's $80,000 that was still owing on the profit portion, but the original deposit also has to be reimbursed. So if the original buyer gave a deposit of $100,000 to the builder, part of the assignment transaction is for the assignee to pay that $100,000 back to the assignor. So we have to work out all those numbers and make sure they're properly set out in Schedule B, which could be very confusing. So some other issues that I want to bring to your attention. I want to be mindful of the time here. Builder has the ability to terminate an agreement if certain conditions are not met. An example was a Cosmos project in Vaughan. The builder canceled the project because he couldn't get their financing. So then the issue becomes, can we get the deposit monies back? And that's why it's important to look at what those coverages were, whether it was a Terrian coverage or a condominium. There's statutory coverage on the Condominium Act. Other issues that come up, closing costs sometimes are way higher than anticipated. As I went through on the adjustment clause, if someone gets hit with $15,000 or $20,000 on closing that they weren't aware of or didn't understand because their agent didn't explain it to them at the time they signed their agreement, or their lawyer didn't explain it to them at the time they signed their agreement, they're not going to be very happy clients with either of us. Did they get mortgage approval? They have to get mortgage pre-approval. Usually there's a time frame in an agreement of purchase and sale that says you have to provide the builder with evidence that they've been pre-approved with their mortgage within so many days of signing the agreement. Sometimes if they miss that, the agreement can be terminated. Oftentimes buyers get pre-approved, but the amount they get pre-approved is for a certain amount. Because of the time delay on these closings, it's created an issue because sometimes market conditions have determined that we've come to the final closing and the lender does an appraisal. It turns out the appraised value is less than the purchase price. So it doesn't matter that they got pre-approved for mortgage financing based on the original purchase price. Oftentimes the lender is only going to lend them money based on the appraised value. If that's less than the purchase price, the buyer has a problem, has to come up with additional funds that they may or may not have. So that becomes an issue. Sometimes builders can't get an occupancy permit, have to extend transactions. We have to look at all the extension rights that are in Schedule A. Sometimes buyers just aren't happy with the property. It's not as promised. Sometimes the amenities aren't built the way they were described or the way they were advertised. Oftentimes we're closing occupancy closings, people are moving in and the amenities and condos have not been built. Sometimes they're built by the time we get to final closing. Sometimes they're not even ready at the time of final closing. That can become an issue. Common expenses sometimes are higher than they were advertised. Builders generally, when they're marketing these condos 3 or 5 years before they're finished, they're just estimating what the common expenses are going to be. And there's always something in the language saying this is an estimate and they can charge whatever they actually are, the real charges are going to be. Sometimes it's a marginal increase or inflationary type of increases. Sometimes these are really significant increases. So if someone was expecting to pay $400 a month in common expenses and 5 years later it's actually $600 or $700 a month, that's pretty significant. They have to know that there's a risk in doing this. So it's your job and my job to make sure they understand that. Sometimes there's damage to the property. There's a Terrian process to make sure these damages get fixed by a builder. Terrian also gets involved in making sure that the builders get projects completed. If a builder goes down, Terrian sometimes will step into a project and deal with deposits, deal with the deposit protection. Oftentimes they're trying to find another builder to complete the project, and if it's viable, to keep it going. And sometimes they do that, they might complete the project, but the process might be that any agreements that have already been signed are terminated and deposits will go back, and they might give those buyers the first opportunity to buy again from the new builder that's taken over the project. A couple other points just so you know, there's always a schedule of warning clauses attached to these agreements that could go on for pages and pages. There might be noise vibrations from planes flying overhead or proximity to trains running by, things like that. There's restrictive covenants and subdivision agreements that restrict people's ability to use their property to some extent. Basically saying you're buying a residential property, you can't run a commercial activity out of your property unless there's certain allowances for that in the bylaws. Those type of things are also in his schedules, and that's why these agreements are often 30, 40 pages long with all the schedules. So these are other things you just have to watch out for. Important thing to know is lawyers and real estate agents are a team. We certainly look at that we view the world that way, and we view real estate that way in our office. We consider you to be our teammates. We're acting for common clients. We want to work with you. We want you to work with us on these things. We have to be on the same page. We're available to help you advise the clients. If you're not sure about something and you want to give proper advice to a client, any of these things, ask us. We have a team of 6 lawyers that are all very qualified for dealing with this. We have a bunch of really highly qualified clerks that can answer a lot of questions as well. If you can't get me, you get, and I'm involved in it, you ask for one of my partner, you ask for one of the other lawyers. We're all prepared to jump in and give you quick answers on these things. And you have to work with us. And if an issue comes up, we're never looking to throw you under the bus to say, oh, your agent should have told you this, or your agent should have explained that to you. That's not the way we operate. And we expect that you would operate in a reciprocal fashion. We're trying to get the same result. We're trying to get a good result for our clients. We all want repeat business. We all want referrals. We want it to be done properly. So I can encourage you, make sure, if you're not getting it to our firm, and obviously we're encouraging you to get this to our firm, but make sure you get it to a qualified lawyer. And not all lawyers deal with this properly. It's really important. Make sure you get it to a lawyer during the statutory 10-day cooling off period if it's a condo. Make sure you get a condition in there that's conditional on lawyer review if it's not a condominium, so we get a chance to look at this. And we'll help you through it. We'll work with you. We're a team, and we look at it that way, and we try and get the best results for our mutual clients. So I'm sorry if I went over a little bit, but I'm certainly available to answer any questions, and thank you for tuning in.
Hey, David, sorry, I was trying to unmute myself. So there are a few questions. I think some have been answered. I do want to really insist. I've had some people that I did not represent in buying pre-construction. They were international buyers, and then they eventually had to reach out to me on the time of closing, where everything was falling apart because the agent that did represent them did not introduce them to a lawyer right up front at the cooling period. And then I had to go to the Kormans, and Jonathan had to save them and pull them out of that mess. And literally, like, months later, we are still tackling the issues that they were faced with. So it is extremely important that through that cooling period, and so many realtors don't think that it is that you find your lawyer, you get the paperwork to the lawyer, and let them take care of things beyond that. There's a couple of questions. I think Laura had one question. Laura, you can unmute yourself and ask that question directly to David, if you like. I think there were another couple of questions also. Laura, are you able to unmute yourself? No. Guys, whomever has a question can unmute yourself. This is a meeting. Yeah.
Can you hear me?
Yes, I can. Yeah.
Okay. The first one I had was only condo. Now I forgot what we were talking about at that time, David. Because you said, and I said it's not on freehold. Is it not on freehold construction?
Yeah, this was catering to everything, freehold and condominiums.
No, when we were talking of something specific, or the 10-day cooling period, is it only on condos, or is it also on freehold properties?
Only on condos.
Okay.
That's only on condominiums, because it's part of the Condominium Act that provides that 10-day cooling off period. If it's not a condominium, there's no condition. You have to put a condition in the agreement of purchase and sale, make it conditional upon lawyer review.
Thank you.
Thanks,
And
Laura.
Regina, I think you had a couple of questions.
Oh, hold on. Can you guys hear me?
Yes.
Yep.
Yes.
Yeah. So I think I have to look at the chat what I asked, because I asked so many questions. Do you help the clients? Yes. Who does, and where do we go if they want the rental rebate? Because I know I have a lot of clients that right now they do have the tenants, but they want to get the rebate. Can we do it through the lawyer right at the same time? during the kind of the final closing kind of thing?
Well, you're talking about the rental rebate for an investment property, right?
Yes.
Well, that has to be done after closing because you have to own the property. You have to show the government that you closed and send them a copy of your agreement of purchase and sale. Send them a copy of the statement of adjustments showing them that you didn't qualify for that HST new housing rebate. So you had to pay that amount. So you have to show that. But you also have to send a copy of the lease, and you can't enter into the lease prior to closing. So it has to be a lease that's entered into after closing.
No,
so the process for that starts. So it really creates a bit of a cash flow issue because they're going to pay that amount to the builder, and it might be a few, 3 or 4 or 5 months later that they get the money back from the government after the rental rebate application is done.
And you do have to have that 12-month lease signed, Regina. And on the flip side of it, I actually purchased a property which was, somebody had closed. They never lived in it. They applied for the rebate. When I took the property over and it was for rental and I had a 12-month lease, I actually applied for that HST refund. So they were quite upset because they had to return that money because they had never lived in it. And they had said that they were buying it for themselves. So they had actually opted out for not paying the rebate for when you're closing, they never paid it, saying that they're going to move into it. And then when I bought that property and nobody had ever lived in it, I got the HST refund, which is 13% up to $24,000.
Okay, so basically what you're saying, David, that now it's only after the closing, not after the occupancy, because they actually rented out during the occupancy. They had the rentals, and right now they're still in there. And I think you were doing the Walid the case. And right now I did tell him that when you're gonna close, please remind me, and I'm just reminding myself right now to call him and to tell him to make sure that you get that rebate, because I knew that you have to close, but at the same time, they had this weird that you cannot do the whole, you can do a whole year, but it has to be month to month basis. So they have a lease where it's a month to month because that's what the builder requests, but they're over there for the last year anyway. So how do we look at that?
Well, if the builder consents to allow someone for it to be rented out during the occupancy period, that's fine. You have to look at whatever those conditions are, but they still won't be able to apply for that rental rebate until after the final closing.
Which just happened recently.
Because sometimes, that occupancy period could go on for a year, like in that situation, right? So if you just think about it, if they would apply just during the occupancy period, and the government then pays them that amount, and then it comes to final closing, if that buyer doesn't close with the builder and defaults and doesn't close for some reason, the government's now out of the money. So one of the requirements the government wants to see is that there was a closing, because on the final closing, that's when the buyer would be paying an amount equal to that new housing rebate to the builder. Okay. So it logically means that you can't really apply for the rental rebate until after the final closing.
Because you already paid. Now, I have a second question. What if you sell the assignment when it comes to the HST? Do we have to, who pays the HST? You can actually literally, it's all confusing who would pay the HST. If we just sold the assignment or we just purchased the assignment, who is whether it's an assignor that's supposed to be paying taxes? Because you said that there's 3 HSTs that are involved, like the builder, assignor, and assignee.
Yeah, and I appreciate it's confusing, and we'll do a seminar on that because I can't give you a short explanation for that. Like that's an hour-long discussion about the different elements of these things. But I will give you a couple critical things to look at. First of all, it's a negotiated point that has to be negotiated between the assignor and the assignee as to who's responsible for paying these things. So it's important, as part of the negotiated assignment agreement, purchase and sale. But as it relates to the HST new housing rebate, something that's really important for the eligibility for that rebate when you're dealing with an assignment. What the government looks at is what was the intention of the original buyer when they signed the agreement of purchase and sale. Did that original buyer intend to move in for their own purposes and they would have normally qualified for that rebate? Or would they not have qualified? Because they don't look to see what the intention of the assignee is. The assignee moves in for their own purposes. There's situations where an assignee buys it, moves in for their own purposes, but they don't qualify for the HST new housing rebate, even though they moved in themselves as their principal residence. And the reason they don't qualify for it is because the original buyer didn't qualify for it. So they look back to the intention of the original buyer. So this all gets very confusing and it's complicated. And that's why I'm saying, you know, we need a seminar just on that itself. Okay. So anybody that wants to be doing these things and wants to do assignments on pre-construction, you have to make sure you attend our seminar on that and get the materials for that, because there's a lot of issues. Okay. There's also land transfer tax issues. Yeah. There's capital gains issues. There's other tax issues that come up on assignments.
Guys, as David had mentioned in his email, we have a 3-part series to this. And we're gonna, you know, have assistance from David Korman for that. So the assignment is the next part to this series.
Okay.
Just for everybody to
tune in.
Thank you.
Tune in.
More to come.
I'll be there.
Same bat channel, same bat time.
Yeah. Thank you so much, David. You know, this was wonderful and always enlightening to have you over in these sessions.
Well, my pleasure, and I wish everybody best of luck in getting out there and dealing with new construction. It's a great thing to get into. It can be very lucrative. You can ask some of your colleagues that have been doing it, and you'll find it's a very lucrative way of doing it. You just have to make sure you do it properly and get proper assistance, and then you're off to the races. And once you do, you work through a couple and listen to the other materials that Sabiha is going to be providing and David's going to be providing to you. I think you're going to find it very interesting and very challenging and hopefully very beneficial. And don't hesitate to get in touch with me or any of the other lawyers in my office at any time if you have any further questions. Even from today's webinar or other issues, we're always available for everybody at Sutton Summit.
My quick advice is this is a recorded session if anybody wants to skim through it again and take some pointers. And when we have David on board for our second part 2 of this, then maybe we can tackle with some other questions as well. Thank you everyone for joining. Have a great day.
Thank you. Thank you.
Bye-bye.
Bye-bye.
Thank you, everybody.
Oh,